Hello and welcome to Scrutiny. I'm Edward Rooney. Supermarket wars are nothing new, I suppose. The fight between Foodstuffs and progressive enterprises has gone to whole new levels though, with a drawn-out plan by Foodstuffs to open a supermarket in Wairau Road. This pitched battle has gone on for 18 years. Foodstuffs Auckland Managing Director Tony Carter is with us. Welcome, Tony. So, congratulations on getting a victory here.
Thank you.
Is Justice Fenning's decision on this the final word on this pack and save outlet?
We hope so. There is a potential for Progressive to seek leave to appeal to the Court of Appeal. That is not automatic, and you first have to go to the High Court and ask Justice Fenning as to whether he will let his decision be appealed. If he declines it, they then have a further opportunity to go directly to the Court of Appeal and ask for special leave to appeal it.
Are you I guess you can't say definitively, but are you sensing that this is it, or from the signals that you're getting?
We have a resource consent, which is a valid resource consent, and we're basically sick of the delays. So we are proposing to open the store in May, and even if Progressive are granted leave to go to the Court of Appeal, it does not invalidate that resource consent, and we would still be able to open.
Okay, all right. So now, Progressive Managing Director Peter Smith, after the decision was Justice Fenning's decision came out, says that this will undermine confidence in district plans. Can you see his point on that?
No, absolutely not. It's a load of nonsense. This is a discretionary activity that is specifically allowed for in the district plan. What the district plan says is that there are things that are what they call permitted, which let you do as of right, and you don't need a resource consent. Then there are things that are discretionary that you have to control some effects like traffic or things like that, which are permitted. Then if you control those effects, they then become permitted. And then there's what they call non-compliant or prohibited activities, which you can't do. This is discretionary. It was foreseen by the planners when they wrote the plan that a supermarket would be allowed on a site like this. It's absolutely nonsense to say it undermines confidence in the district plan.
Okay. I mean, the fact is, though, that it was discretionary, so it was a matter that was signalled to be, that should be discussed.
Correct.
By local officials, by commissioners, or someone would be expected to make a decision on it, and Progressive successfully challenged it for 18 years. So there must have been something about it that managed to hold this up.
Well, the most recent history was that it went to a resource consent application by North Shore Council, which was heard by independent commissioners, who determined not only that it should be granted, but it also should be what they call non-notified, which means that parties that aren't directly infected have no direct input into it. Progressive appealed that on a technicality, what they called a judicial review, and the High Court ruled that it was an activity that should have gone through a bit higher standard of notification. So that was nothing to do with the merits of whether there should be a supermarket, it was purely the process that was followed. What then happened is that we said, okay, clearly it should have been notified, so we resolved that we would ask the council to notify. It's the council's decision as to whether to notify an application or not ours. Right. But they chose in the first instance back in 2003 to treat it non-notified. We subsequently said, please notify it so we don't get into this nonsense as to whether the right process is followed. That was then heard by independent commissioners, who resolved that the consent should be granted. Progressive appealed that to the Environment Court. The Environment Court determined that the consent should be granted, and that's where we are today. That then went to the High Court on a point of law, which is what Justice Fenning's just ruled on.
Right, okay. Sometimes, but these district plans, it did seem to have a reason for this to be a discretionary activity, though, because it's a former industrial area. Wasn't there some leaching on the site that needed to be remediated from a neighbouring activity?
Well, a couple of points there. I think firstly, most supermarkets and most district plans in New Zealand are treated as discretionary activities, and that's right and appropriate. So they had come into some scrutiny as to whether they mitigate the traffic or they do these sorts of things. That's not uncommon. In fact, I can't recall a situation where we have not had to go through a resource consent process in terms of a discretionary activity for a new store. But that, as I say, that's something that's right and proper. The question is how much discretion the council have to oppose it. The second point you raised was it is very common for industrial sites from previous activity to have some level of contamination. And I think one of the neat things about this is that we've taken a site that did have a small level of contamination and have been able to fix it and mitigate it so that contamination, so we've actually cleaned up the environment as well.
You had to go quite low on that site, excavate quite low and clear it out. Is that what
We've done some of that, and some of it's resolved around basically putting liners and things in to prevent any contamination rising up into the store.
Wow.
We have gone beyond what we're required to do, simply to ensure the safety of our staff and our customers.
Okay. The traffic objections that came up through this case, some of them appeared to have merit because the traffic plan for that area has changed significantly from the first decision that was made to the 2003 decision, hasn't it?
Well, what's happened subsequent to the original resource consent application, it was declined by the Environment Court. That was for a very different store. Firstly, it was much larger. It was 6,500 square metres. The current store was just under 5,000. Secondly, there was some traffic issues around Arches Road, and for those that will know the site, that's on the northern side of the site, and we purchased some additional land that would allow the intersection to be lined up. So it's actually quite a different activity, and I think probably the best example of that is the traffic engineer of the North Shore City Council opposed the first application but supported the second application because he could see the difference.
So the process has actually improved the project as far as some people are concerned, such as traffic plans.
Certainly we have no complaints about the first resource consent that was applied for back in probably 1990 something and was rejected by the Environment Court, I seem to recall, in 2002. We have no problem. That was fair. That was a fair process. The proposal since then, which we listened to what the Environment Court said in 2002, changed the plans. The process since then has been for exactly the same proposal. Nothing's really changed about the current proposal through the 5 or 6 years of the planning process that it's taken.
Okay. How much has this money cost? How much has this fight cost your firm?
Huge amounts of money, in the millions and millions.
Ballpark, tens of millions?
So I can't go there.
No.
But millions and millions and millions of dollars.
The other guys, how much would you reckon it's cost them? Less or more?
Probably more, because Russell McVeigh aren't cheap.
How much money has been lost by not having a supermarket there in that valley all this time? Because I'd heard that a supermarket can typically turn over $1.6 million a week.
That the projections for that store are in the court were detailed, so it's a matter of public record, but they're of that sort of scale. So it's very significant, and the benefit to the customers that has been delayed for so long. The point from Progressive's point of view is that essentially, while they were spending money opposing the store, and a lot of money, it's probably less than the money they thought they would lose by having the store open from the profit from the 6 stores that are closest to this store.
Because I guess their reasoning was, throwing all this money in there, they're still getting the money from their supermarkets in the area.
Correct. They were commercially incented to delay for as long as possible.
All right. What will it be like for you to see the doors finally open?
It'd be an amazing feeling. It's been a long time, and you live and breathe this particular store. It's we've opened, I don't know, probably 15 or 20 stores in the period in which we've been trying to open Wairau. So, but this one will be special.
Does the building now comply with the current building standards? Has it changed
absolutely.
During the last 4 years? Has standards changed?
Not that I'm aware of, and certainly no. We got a building consent just before Christmas,